You've ignored the phone calls. You've not opened the letters. You've even ignored a statement of claim. So what's going to happen to you next? And of course, don't forget that some of those little things that we've just talked about then can be skipped and you can go straight on to...
statutory demand.
So, thanks Cheryl. I'm James. Tell us what happens with a statutory demand.
So a statutory demand, basically, once again, is a legal letter setting out the amount of money that you owe. And even at this late stage, you still have the ability to have that set aside if you disagree with it. But I guess...
But you've got to go, like it's at court. This is serious. This is in court. There's lawyers involved typically at this sort of situation. The threshold for these went up just during COVID. Because we'll remember last year there was a whole... They pushed back the whole period for how long do you respond to this. Well, it's gone kind of back to the old days.
It has.
21 days.
21 days, yep.
And if you ignore it, you'll go back to that default judgment you're talking about before. So if you tried to ignore one of these, what happens?
So if you ignore one of these, the creditor can go back to court and wind up your company.
Right.
So you've got 21 days, essentially, to do something about this.
Right.
Now, during this period, as I said, you can have it set aside if you disagree with it. But this is not just a matter of filling in a form anymore. This is a matter of engaging a lawyer to go to court and argue your case. You can, once again, ring the creditor and enter into a payment arrangement. But the other option that you still have at this stage, if you really believe that you don't have the ability to pay, if you don't believe that you are going to be able to pay and you think that your company is probably not doing too well, is at this stage you can still appoint your own liquidator or your own administrator.
Right, so you can sort of make the decision to fall on your own sword before that decision's taken out of your hands.
That's right, yeah. And at this stage, from the date that you receive this, you've got 21 days to do that. Once the 21 days expires, at that stage, particularly if they're an aggressive creditor, you can assume that they're getting a court date to get a wind-up application. And once that's issued, then control essentially is taken out of your hands.
It's all over, pretty much. It goes back to a lot of that thinking that we've been sharing over the previous episodes, is try and get onto the front foot. So in this scenario, you've either ignored it or you've vehemently refused to pay. Now, in this situation, the tax office might have hasn't sent you all of the statements of claim and things like that. They've given you phone calls and emails and texts. They've gone to a statutory demand. So it's pretty serious. It's going to be on the record. You can go to court to get it set aside, but you need to actually go to the trouble of having it set aside. If you do not do that, then it's in the hands of the creditor they could then go to court and make an application to wind you up.
To wind up the company, that's right, yeah.
So this is where it gets really important about some of the things about it. We've talked about all the way back to previous episodes about denial and fighting and heading your head in your sand. If I look at what's happened after the COVID scenario, more of these letters are being sent out, more of these statutory demands are now being issued, and that seems to have now forced people to act. Lawyers are telling me and telling you that these have now been issued now. So,
no, I agree with you, James. I think there's a lot of creditors who haven't had the ability to collect money during COVID, and now they're saying to their lawyers, you know what, we're not interested in mucking around anymore. Let's issue a creditor's statutory demand. Let's get something happening here. Okay. If these people won't pay us, let's wind up their companies. So these need to be taken seriously. But let's also go back to the registered address of the company, because once again, if the registered address for your company is not correct, then these stat demands can be served on an incorrect address, and you may not know anything about them. You may not know that they are being served.
What do I do then?
Then the first thing you know is that you probably get a lot of people ringing you, telling you that your company's about to be wound up, or maybe a letter from a liquidator telling you that he's been appointed to wind up your company.
That's a whole can of worms. Let's keep going. A reminder that these podcasts are general in nature and do not constitute advice, and they don't take into account your personal circumstances. So if you think, though, that some of the issues raised might apply to you, you should seek qualified financial, legal or counselling advice.